Good morning, everyone. Thank you for joining us. I am Interim Dean Michael Hussey, and it's my pleasure to welcome you to the second hour of our Law Review Symposium CLE on pandemic practices, COVID-19, and its impact on the law. This week, we are fortunate to be talking about COVID-19 and its effect on criminal law. And so at this time, I'd like to turn it over to David Sweetman, who is the Law Review, the Commonwealth Law Review's Symposium editor. David?
Thank you, Dean Hussey. And I want to thank everyone for coming today for our very stacked panel for our criminal law panel. First, we have Judge Ed Marcico, who is currently a judge in the Dauphin County Court of Common Pleas. Before that, he graduated from the University of Notre Dame, where he received his JD. The JD from Dickinson School of Law. And he was the longest running district attorney for Dauphin County for 18 years. We also have current York County District Attorney David Sunday. He started his career actually in the Navy, so we want to thank him for his service as well when he was 18 years old. After that, he received his JD actually at night school here at Widener, and then in his finance degree from Penn State University. And also we have Attorney Jason Mattioli. He graduated from King's College, Thomas M. Cooley School of Law, and has been since practicing a private practice specializing in criminal defense and personal injury litigation for the past 20 years. In 1 week, it'll be 20 years. And then as our moderator today, we have Professor Buchanan Raphael. I did not have the pleasure of having Professor Buchanan Raphael. I actually had Professor Dean for criminal procedure and criminal law, which she now teaches. She received her SJD from the University of Virginia School of Law. So as I said, we have a really packed panel and I'm really excited to get this thing going. So without further ado, I'm going to turn it over to Judge Marcico because I know you guys don't want to hear me talk this whole time.
Thanks, David, and thanks for the invite. Very honored to participate in the panel here today. So I've been asked to kick off just talking a little bit about the effects of COVID-19 and the pandemic. You know, obviously the initial effect last year was a total shutdown on courthouses across the Commonwealth and really across the nation. And, you know, after we were over that initial shock of everything shut down, it was, what do we do now? How do we make sure that, you know, the wheels of justice, which turn slowly anyway, are still going to turn here going forward? So I think here, and you'll hear from you know, both Dave and Jason in a few minutes, you know, sharing their experiences in different parts of the state. But I think, you know, the primary response was let's do what we can. Let's utilize technology, which the courts admittedly have not been very good at using. You know, Pennsylvania is one of many states that forbids cameras in the courtroom. You know, has a lot of somewhat restrictive rules regarding new technology. So the Supreme Court, you know, initially came out with a series of orders that allowed things like the use of technology, you know, to make things work. You know, it became apparent to us right away, jury trials were going to go out the window. You know, how are we going to do jury trials in a pandemic? And in, you know, criminal cases, we have Pennsylvania Rule of Criminal Procedure 600, which provides time constraints on, you know, the time within which someone must be brought to trial. Generally speaking, 180 days if they're incarcerated, 365 days if they're not. So the Supreme Court suspended that rule. Most president judges across the Commonwealth also adopted local rules that mirrored the Supreme Court's suspension of things like Rule 600. And then it was, you know, a process of, you know, what can we do? What are we going to be able to accomplish here? I think most counties took a hard look at their prison population. In Dauphin County, we have both the Dauphin County Prison as well as a work release center. And we engaged in furloughing a lot of individuals or releasing a lot of individuals that were incarcerated or at our work release center because last March and April we were very concerned about the risk of the spread of COVID in a overcrowded correctional facility. So here in Dauphin County, we saw our average daily population at the prison go from probably like 950 to 1,000 to down to around 750, which is the lowest I can remember it in over 30 years of practicing in this county. And that took a joint effort. It took the court, the DA's office, the public defender's office, the private bar, all as well as staff at the prison, to identify individuals that could be released, that weren't a threat to public safety, and work on release plans for those individuals. So it really was a group effort put together in a short period of time. Our work release center did the same thing. They usually have over 200 people and dropped that down significantly also. I handle our drug treatment courts in Dauphin County, and we were very concerned. The whole purpose of treatment courts is to have participants come before the court on a regular basis. The theory is that connection, with the court will hopefully impact them and help them in their recovery. So we knew we weren't going to have people coming in the courthouse. So very quickly, we were able to use a sort of a knockoff of Zoom, I'd call it. But we didn't have laptops or anything like that. Everybody used their phones to do our drug court check-ins for a couple of months. But we thought it was very important that those individuals, have that ability to check in with the team, not so much with me, but with, folks from our drug and alcohol department, to make sure that they were getting what they needed. So the treatment court was a priority. We were in juvenile court, where again, you're faced with, rules of procedure that call for very quick turnaround in, how quickly those cases must be handled. We shifted pretty quickly to a video system to do juvenile court cases. Fortunately, most of the detention facilities had the video capability right away to do that. But there were many juveniles who were at home who, had to participate, on their phones also. We got to the point last summer where Judge Morris, who's the jurist in residence at Widener, and I handled juvenile court, where we had to remind many of our participants to put on a shirt and get out of bed when they were going to be in court before us. But again, we were able to keep things going with juvenile court other than hearings. The adjudication hearings, much like jury trials, were put on the back burner because there just was no practical way of doing those at that time. One thing that the technology was very helpful in adult court was doing guilty pleas and revocation hearings for those that are in the prison. I think probably will make use of this going forward, cutting down on transport that the sheriff's office would have to do, bringing individuals from prison into the courthouse and all that goes along with that. The ability to do guilty pleas from the prison and have those cases continue to be handled. Took some getting used to, but I think it is probably the wave of the future. Now it creates issues, for defense counsel and things like that. I think a lot of us, whether the judges themselves or court staff, we've become pretty conversant in getting people in breakout rooms and setting up things like that, so that counsel has the ability to talk to their clients, in those types of situations. Along those lines, I handle protection from abuse hearings, which are civil proceedings, but can end up being quasi-criminal if there's a violation. And we handled most of those by video. And the good thing we've learned with video in a lot of these proceedings is the ability to mute participants, whether attorneys or self-represented litigants that are talking over each other. Believe me, when we were back to full-time in person, I'm going to miss my mute button going forward. It's a power that I've never had before. So there are certain concerns, obviously, with doing things by video. Obviously, the right of confrontation, in criminal cases is, a constitutional right. Obviously, is that met if we're doing proceedings by video? Does that comport with the confrontation clause? And even if we're not in video, if we're in person and somebody's wearing a mask, does that comport with the confrontation clause? There have been some challenges in different jurisdictions on both of those lines that I've reviewed, and for the most part, it appears that video, different state courts that have decided it seem to have said, no, the video, can comply with the constitutional requirements under the confrontation clause. We in this county, late summer, early fall, did start bringing jury panels in to, we'd had jury trials on hold for several months. We did jury trials, I think, August, September, October. Then with the surge in the number of cases, we took a break again, November, December, January, and February, but actually just are completing a jury trial week this particular week. That necessitated a whole change in how we do things. We were asking jurors to come here, in a pandemic. I was so impressed with the response, the number of people that showed up. I thought we would be, scrapping to get people in here and having to pick people up off the street. But, a credit to the resiliency of our citizenry that they would come in, and willingly serve as jurors. Very few, refused to come in. Obviously, we took precautions. Everybody masked in the courtroom. We had to change. We have a jury assembly room where we would bring a couple hundred jurors in, and then farm panels out to the different courtroom. We now had to select each panel in advance of a court date, a trial date. So logistically, that meant summoning a whole bunch more jurors than we normally would, and sort of changed our system. Some things, again, we learned for the better. Other things, more difficult. In my courtroom, we have jurors that have to sit out where the audience would have been, to comply with spacing. We have 6 jurors that are in the actual jury box. Then a couple behind counsel, a couple out in the audience. We've had to move, counsel table. The first time we were doing it, I realized that jurors were sitting right behind counsel table and could read anything on a laptop of the lawyer. So we, again, no one was doing anything nefarious. Just was the way none of us had thought about. What do we do? In these situations. So, I think we'll see, hopefully we're coming out of the pandemic now, but I think some things we've learned is making use of technology, for things like pretrial conferences, instead of running a lawyer in here, to the courthouse that might have an office 20 minutes, a half hour away, or be doing, prelims all over the county, they can do a 10-minute, 15-minute pretrial conference from their car, things like that. I think we'll see changed. I think we'll see pleas and revocations continue to be done remotely, but for the most part, I'm a believer that there's a reason we have a courthouse and a reason we have courtrooms. Especially doing juvenile court, I think the impact on juveniles, not that my lecture is going to save anybody or anything like that, but there's something to the formality and the solemnity of the proceedings, that I think is important. So I am hopeful we get, back here, sooner rather than later. I teach a class at Widener, and teaching this past fall by Zoom, again, you just miss that in-person interaction. A couple other judges now are going to put together we're hopeful to get published all the different things we've seen, individuals vaping. I literally did a guilty plea where somebody was in a bathroom stall somewhere. I had people tell me, look where he is. It looks like a stall. I'm like, no, it can't be. And sure enough, the guy was in a bathroom stall. We could see the toilet behind him. And one of the other things we've seen is lawyers, having a client at their office for a hearing, and then, on cross-examination, the lawyer telling the client what to say, turning. I've had to remind several lawyers, you can't do that. Good lawyers, but it's just, we're not used to this type of thing. I had to say, counsel, your client's on the witness stand. You cannot, give an answer on cross-examination. So that's sort of been our experience here, David.
Perfect. Awesome. Thank you so much, Professor. And I was part of that class in the fall, and it was fun. You made it worth it, though. So we made it work. All right, now I will turn it over to District Attorney Sunday.
All right, good morning. It's great to be here. I'm going to try to put out a lot of information here in a short period of time. And so I want to start with, when we talk about COVID and its impact on the criminal justice system, when we look at the York County District Attorney's Office, for example, we have around 10,000 criminal cases a year. We have 100 employees in here. And I'm sure that Judge Marcico and everyone else that has practiced law will tell you that our system is very delicate, in that there are so many different moving parts and so many different competing interests, that when you throw into the mix a global pandemic that at any given time can put people on quarantine for up to 2 weeks in a lot of cases, it really creates some difficult situations. And I tell you that because when you think about the 10,000 criminal cases, they didn't stop. And we knew when this started that we would have to balance essentially a health crisis with the community's desire for public safety, and also clearly defendants' constitutional rights. And so with that setting, the very first sort of crisis we hit was within our prison. Right off the bat, our warden reached out, and a lot of people, I'm not sure if people know this or not, but in most counties, the elected DA is part of what's called the Prison Board of Advisors. And so they help dictate policy for the prison. They work with the warden, and that has really given me an insight into the difficulty that COVID has done to prisons, right? And a lot of people didn't understand why that was important to us. Well, very simply, the health of a prison directly impacts the community around it. Here in York County, when inmates get sick, there's not a hospital at the prison for them to go to. They go to York County Prison. And it was a tremendous fear on the part of our warden and on the part of our corrections officers that there would be an outbreak. So the DA's office, we actually took about a week, and we audited every inmate in the prison to determine whether or not there was a chance for them to be on bail, supervised bail, potentially monitored with GPS, drug and alcohol monitor, bracelet, and things of that nature, just to be able to put the prison in a place where they could stay ahead of it. We have a work release center that the judges here in York County shut down during this time period. And so all the inmates who were on work release essentially went home. There were one or two that stayed in the prison due to different reasons. But our biggest fear at that time, in addition to an outbreak at the prison, was the reality of what happened to people that were in our treatment courts, people that are in our pretrial diversion programs, people that are on probation and parole that are in the throes of addiction. And Judge Marcico touched on it, but I will tell you, probably 70% of all the cases in York County are either directly or tangentially related to drug abuse. And for people to successfully make it through treatment, they have to have that human contact. And AA, NA, a lot of our outpatient treatment facilities shut down immediately. And that put us in a position where we had thousands and thousands of people who are in the throes of opioid addiction that were just left at home. A lot of them were furloughed from their jobs. We had people who had stressors in their lives that they haven't had in decades. And we are now unfortunately seeing the grim result of that, in that last year we had over 200 opioid deaths in York County, which was well over double the year before. And so that was a very difficult issue for us. It was something that we worked very hard to try to work through. In addition to that, when you talk about the work of a DA's office, I often equate it to an iceberg, right? Like you see the top of the iceberg, and that's like 10% of the mass of it, right? Well, that's sort of like what we do. And when you look at a courtroom, and so criminal jury trials and preliminary hearings are a very small percentage of the total output of a DA's office. We do a lot of work with regard to investigations. We do a tremendous amount of work with regard to preparing for these proceedings. We do a lot of work with regard to our treatment courts, our wellness courts, our reentry programs, and that all takes place through communication with others. And that came to almost a complete halt. And we had to very quickly figure out ways to work through that. Because of inmates not being able to be transported to the DA's office because of COVID, that seriously put, it caused a lot of challenges with regard to investigations. In addition to that, when you think about child abuse and you think about, we'll start with child abuse. The vast majority of offenders who are investigated and prosecuted for child abuse come to light through mandated reporters. So we have people that are school teachers, and we'll just look at teachers, for example. We had children that were just home. They weren't around the teachers, they weren't around their school counselors. And so the individuals who typically identify issues with children, they just weren't there. So the amount of investigations really slowed down. However, I'm going to say the criminal behavior on the part of people towards children did not. And in fact, it was a tremendous worry for us to know that children were essentially locked in their homes for all this time period with their potential abusers. That's the same thing with domestic violence. With regard to domestic violence, we knew for a fact that we had people who were stuck at home with their abusers. That created, they say necessity is the mother of invention, and we came up with a lot of creative ways to communicate with individuals to make sure that they were safe, to put them in a position where they could contact police should the need arise. And this was all in addition to figuring out how to keep prosecuting cases. The office itself changed drastically. When COVID first started and we went through the different court orders, the judicial emergencies, the DA's office, we could not be in a position where the entire office went down with COVID. And so we actually, I channeled my inner pre-law career time when working at UPS, and to the pure pleasure of the attorneys here, I put them on shift work. And so the DA's office went to shift work, where we had people working from early in the morning all the way through midnight to make sure that we could minimize the amount of exposure between litigation teams. And that actually worked out very well for us. And we kept that going until only a few months ago. One of the other issues, obviously, with running an office was with regard to the schools being closed, children being home. We had to work around the needs of the employees in here to make sure the work could continue to get done. We applied for grants and received grant funding to actually purchase computer equipment so that every employee in this office had a full workstation at their home so they could continue to do the work of the DA's office from home. Shifting over now to the issue of coordinating. This is important because, I know that Judge Marcico could certainly attest to this, especially from his time as a district attorney. But whenever you have a hearing or anything of that nature, there's so many different people involved. So we had situations all throughout the whole year where we had police departments who had police officers either with COVID or on quarantine. that put us in a position where we couldn't move forward with the hearing. We had victims who who were quarantined with COVID. Parts of York County doesn't have the best internet. And so we would be in the middle of a hearing, and literally in the middle of witness testimony, the phone would turn off. And so that created obviously a tremendous amount of frustration, not only for us, but for the court, for the defense attorney, for the victims, for the witnesses. And that happened on a regular basis. With regard to preliminary hearings. So in York County, we have 19 MDJs. And one of the challenges for us through the course of this is the fact that each MDJ ran their courtroom in a different way, not a lot of times in a different way. And so we have 4 or 5 magistrate district justices who are strictly Zoom. We have some that are strictly in person. We have some that are a hybrid. And so a lot of this really comes down to coordinating people. With regard to Zoom itself, and I know I'm running out of time here, so I'm going to try to do the best I can here. So with regard to Zoom itself, you know, a lot of the ADAs have been Zooming from our office here, which has worked out. We have witnesses that Zoomed from houses, from cars, you name it. We had a situation where the defense in a strangulation preliminary hearing, we had the victim testifying, and in the corner, we could see the defendant was sitting there. And this is in a strangulation hearing. And so we had to immediately send police over to take care of that situation. And that happened more often than not. We had situations where people were, and this was a big worry for the prosecution. You know, obviously defense counsel has an ethical duty to advocate zealously for their client. We have an ethical duty to ensure that justice is done. And we took that very seriously during this whole process. We had situations where we had witnesses that maybe had other people in the room with them while they were testifying. And we had to put the stop to that very quickly. With the prison still being on lockdown, it's difficult for us to work with inmates with regard to preparing for trial for those that are witnesses. And so very simply, it's been a long year. You know, I will tell you that with all that being said, I'm going to leave us on a positive note here. All throughout the course of the last year, my entire staff has worked tirelessly to identify ways that we've adapted that actually make us better. And one of those in particular is through a shift in resources in the York DA's office to front load the system. I know that in a lot of counties, this has been going on for a long time, but here we have not had assistant district attorneys at all of our preliminary hearings. We identified very quickly the need to make sure that occurred, because when we could handle and handle cases, and when I say handle, I mean either identify a potential plea, well, really that's it, identify a potential plea and work with defense counsel to get people in diversion quicker, to make sure that we identify people that can be in treatment court quicker. That seriously minimizes the amount of resources that have to be utilized repeatedly to bring someone up here to the courthouse. And so we shifted our resources in here to make sure that we have prosecutors at every preliminary hearing. We have, and that was a monumental effort that really probably couldn't have happened but for the time we had to figure this out through COVID. And I think that as we go on and we look at our lessons learned, I think there's going to be many things that have come up through this process that we can learn from each other, from other offices, about how we can actually make the system better. And so with that being said, thank you for the time. I tried to get as much here as I could, and certainly be available for questions.
Thank you, District Attorney Sunday. I will now turn it over to Attorney Mattioli to talk about, the defense side.
Good morning, everybody. It's going to be a tough act to follow, two esteemed colleagues like Attorney Sunday and Judge Marisco. But the first thing I'd like to talk about, I'd like to touch base on something both of those gentlemen said. Back in early February of 2020, I remember my wife and I were having a discussion, and she's in the medical field. She had said, wow, everybody's talking about this horrible situation. That's the first time in my life I've ever, being on this planet 46 years, hearing about the word pandemic. And she had warned me that, wow, my colleagues are talking about this is going to happen. And myself, like others, I looked at her like she was crazy. and said, this is 2020. This isn't going to happen. I mean, this will be fine and gone. And this wasn't a Republican or a Democrat thing. It was just a, hey, I'm all the great advancements in technology. And for the people that are out there that are married, 14 months later, if I told you so, is from my wife, here we are. And why I started with that everything hit and happened so fast. And you have your county's DA's office, your county's judicial bench, and your county's court administrator's office all coming together at once to say, hey, we need to figure something out. We need to keep the wheels of justice moving. We got people in prison, Rule 600, we can't keep them here. They need to push their case forward. We have cases that need to be prosecuted. We have civil cases that need to be pushed forward on the docket. And everybody really came forward and came up with a plan, followed coupled together with our state government on how to keep everything moving. And I have to say, everybody has done a tremendous job. I'm a private practitioner. I just go with the flow. I mean, we have no say in how the courts are going to be run. And it was a really remarkable job on the bench, the DA's office, and the court administrator. So I want to make sure everybody out there knows that those are the people that are responsible for why our justice system hasn't come to a screeching halt and why it has still moved and pretty smoothly. A couple bumps in the road because this is all new. And that goes into me starting with my first topic, and that is Attorney Sunday kind of touched on it, that every magistrate in his district has a different way. Well, we're lucky up here. I mainly practice in Lackawanna and Luzerne County, and we're lucky because we have central court, which means that all hearings of a misdemeanor 2 or higher start at one location, which is great for the lawyers because some of the counties are so big, you have to drive all over the place. But just like District Attorney Sunday had said, every county does their own thing. You'll see that when you practice law, every county has their little tiny differences with procedure or local rules. We're here, Lackawanna County, he immediately went virtual for everything. Virtual arraignments, virtual preliminary hearings, virtual guilty pleas, virtual sentences. Obviously, they had the trials in person, but that was few and far between. Then you have Luzerne that attempted to do everything in person. And it was a trial by error because they had to close down twice because of COVID outbreaks. And the last closure was a tough one scheduling wise because it started in November and they were closed from November of 20 all the way until the end of February of 21. And, the judge and the district attorney could agree with me that it was a scheduling nightmare. All your cases that were on for those 3 months immediately all got moved to March and April. And then from when the people who got arrested from that period were dumped into May. And now it's just a revolving door of constant continuances. And it's really tough if you have a client incarcerated because obviously they have to have their cases come first. And it's just been a complete nightmare. But one part of the COVID situation or the outbreak that I'd like to talk about is obtaining clients. And it's tough being in private practice to begin with, because when somebody gets arrested, they normally go to 3 or 4 different lawyers to feel them out. And I always encourage that. I always tell people that come in that say, I've talked to someone else or I'm going to talk to somebody else. I tell them, look, this is a serious situation. You or one of your loved ones has the potential of having your freedom and liberty taken away. So you need to go with the person who you feel you're most comfortable with. And I always prided myself on being more of a little bit more of a used car salesman than an attorney, because, when you practice law and pass the bar, everybody knows the law. If you don't know the law, you better do something else. It's how you talk to people. It's how you treat people, not just your clients, how you talk to police officers, how you treat judges, how you treat district attorneys. Everybody thinks that, when you become a criminal defense attorney, the second you step into a courtroom, it's a nonstop street fight. And that's just not the case. I mean, the guys out there will tell you 98% of your cases are damage control. And that's because we have the police. This is not in the 80s where, they gave you a badge and a gun, slapped down the butt and said, hey, go out there and arrest people. I mean, they're highly trained now. And they're highly trained at the police academy, whether it's the Act 120 or it's whether at the state police academy. And then they come out and they have constant updates. So, for example, for drug cases, the drug cases are so hard to defend because the police do such a great job. You have somebody who's allegedly selling narcotics. They're probably on a consensualized wiretap, and that just creates all kind of problems for you and your client. So at the end of the day, you're starting off with damage control. And a lot of those cases, they're arrested and put in jail on a high bail, or because they've maybe were on parole or probation and are put in jail on what's called a detainer, meaning your parole or probation board says, hey, you couldn't behave while you're on parole or probation. Now you're going to stay in jail until the completion of your new charges. And that's a tough situation because, you know, when you meet these family members, a lot of times it becomes very personal. You got to talk them down. There's a lot of hugs, a lot of handshakes, and we couldn't do that in the beginning. It was a lot of phone calls, and it's tough when you meet a client for the first time that's in jail behind glass, because they're taking their cues from their family members. 9 times out of 10, their wives, their girlfriends, their fiancés, their mothers, their fathers, they're the ones that are going to foot your bill. And they're the ones you have to communicate with. So it was really, really hard in the beginning, just doing the phone conversations. Then we tried to do FaceTiming, and I hate FaceTiming. I love technology, but I hate FaceTiming. I think it's even worse than talking to somebody over the phone, because you may be able to sit in a nice office and have it all serene and quiet, but you don't know what the people are doing on the other end. You know, they've got kids, they've got pets, maybe they got kids and pets. Maybe they got kids and pets within their car driving on the road, which is highly unsafe, by the way. I made sure they pull over before they would FaceTime me, but that was a disaster. So then my office staff and I got together with, Mr. Sweetman could attest for this because he was present for a good majority of it. And listen, so we're going to social distance. We're going to wear masks. We're going to make sure everybody wears masks. We're not going to touch anybody. We're going to come in and we have a couple conference rooms. We're very lucky to have the space available. We're going to try it out. And we've been successful probably since June of last year. We've had all our clients come in person. We obviously ask them if they're comfortable. We say, hey, we want you to come in and meet you in person, but it's your preference. And we lay it all out to them that, we're going to be safe. We're going to social distance. You have to come here with the mask. If you're sick or you've been around someone that's sick or you've been out of state, you have to tell us. And honestly, I can't think of one time when someone did not listen to us and somebody wasn't safe. And we're very lucky with that. So we were lucky to compete for clients, and we would sign people up, but then you would transfer into, the preliminary hearings, and what something Attorney Sunday had touched on. There's nothing worse than going through a hearing and the screen freezing or getting cut off, like right in the middle when you think you're having a good cross-examination and you got them on the ropes, then all of a sudden, the lights go out. That may have been purposeful sometimes on the Commonwealth's part, but I'm not going to make any accusations on the record here. But another nightmare, and I'm sure everybody can attest to this, is when you have a client that doesn't speak English. And not only do you have them on Zoom, you have the interpreter on Zoom somewhere else. What a nightmare. You want to talk about a true test of patience? You're asking questions that the interpreter 9 times out of 10 does not get the whole question. Then he or she has to interpret back to whoever's on the bench or whatnot, and then it has to go back and forth. It's just a nightmare, and it really takes its toll. I think I miss the in-person hearings because I think it takes a lot away from the adversarial process. You come, the DA sitting right next to you, the cops in front of you, and you put someone on the witness stand. I mean, it's a lonely territory up there. You're up there all by yourself, and you get to score some major points with cross-examination, but then as you see we do it now, you kind of lose that the nerves if you're on the witness stand, and you kind of lose that confrontation. And what's even worse is if you want to show somebody an exhibit, you have to have like a degree in IT to put an exhibit on the board. And we have a company that we work with to do all that, but some lawyers and especially public defenders, it's really tough for them because they can't afford to do that. And then we know a lot of good public defenders in this county and all the counties, and I'm sure the gentleman that spoke before me could attest to this, that a lot of the public defenders are phenomenal lawyers. They're just so inundated with their cases. And now it got even worse for them, where you had a big caseload in the beginning, and now they had to adapt and find a way to talk to people and find a way to do their jobs. And I think one of the hardest things for me normally is, Judge Marisco had touched base on this, is keeping your client under control. I would, when we would go to we would be at the preliminary hearing or an omnibus hearing or a trial, I would give them a notepad, and my exact words were shut your mouth, don't say anything. Everything you say is going to be on the record. If you have something to tell me, don't do it in the middle of cross-examination when I'm trying to, do something, or when I'm paying attention. Write it on the pad and give it to me. Well, you couldn't do that when we were doing Zoom hearings and they were on the other end, and it was just a nightmare because you would have clients, whoa, this is BS, and this is should be suppressed, and the cop lied, and you're just sitting there like, oh. And then they make statements against themselves for their cases, which pretty much is a Miranda waiver, and you're just like, what do you do? And then when you get off the call, well, how do you think it went? Well, how do you think it went? Why did you say that? And then you're getting blamed. So it's just a complete nightmare because it's a tough situation when you get arrested or when you have a family member get arrested. I mean, the stress is high, and a lot of times you just can't keep people under control, and you could talk to them until they're blue in the face. You can lead a horse to water, you can't make them drink, and sometimes the emotions get the best of them. On another note, what I liked about the Zoom hearings was a pre-trial. In Lackawanna County, after your prelim, we have our first pre-trial hearing 6 weeks later. What's nice is doing it by Zoom, because if you had only 1 or 2 cases, sometimes when you would be in person, there would be a list of about 150 cases. So it would take all day, literally, for you to get your 1 or your 2nd case called. Where here now you're on Zoom, you can do some work, you can take some phone calls. You're just not inundated to being in court. But what also it was hard too was the screeching halt of jury trials. Mr. Sweetman could tell you, we tried 3 cases in 2019. And when you're in law school, you get this mistaken belief that you're just trying cases constantly. And that's just not true at all. I mean, because you can't do that. I mean, you really have to, in the beginning, to go back on what I said, determine if this is damage control or, if it's something you can fight. And if it's damage control and your client wants to fight it, you're pretty much, walking them off a plank. And it's a different, I'm sure, Attorney Sunday and Judge Marisco can attest to this. It's a different situation when you're offered a plea and you take the plea versus, you tell the police, here's what you can do with your plea. Let's go to trial. Then you just get crushed if you lose that sentencing. I mean, crushed. Some people get sent into the ozone layer. So because they're tried on all those charges. Very rarely do you see an offer where, hey, plea to everything, unless it's like a serious homicide or something along those lines. 9 times out of 10, your client will get charged with 4, 5, 6, maybe 7 offenses, and you'll be able to work out a deal depending on the victims and the nature and the severity of the crime, and depending upon their criminal history if they have any. That all goes out the window if you want to push the trial. So we had 3 cases last year, 3 defendable cases, and then we tried nothing in 20. And now in 2021, we've done some omnibus hearings, but we have not been able to get in front of a jury yet. And it seems to be like just an intense, crazy process where you're opening up in April. You don't know how long you're going to be open. Could be open for a month, could be open for 2 months. I'd like to be able to think that everyone is going to be open for forever. But, there's the voice in the back of my head of my wife telling me I told you so. So I'm a little bit more reluctant to disagree with her now. But it's just a really tough process. And from the private side, from signing up the clients, I love to do hearings live, like we talked about. That's harder. And just picking a jury. I mean, I have not had the pleasure yet of picking a jury in the pandemic. I know some lawyers have. And I think the only difference was the location. Like normally your county has a jury room. It's a large room. They put maybe about 100, 150 prospective jurors, and you get to do your selection there. Where here they had to switch them to maybe the Jewish Community Center up here in Scranton, or the Masonic Temple, or and I know in Luzerne County they were doing jury selection and some trials at the Wachovia Arena. So it's just a matter of adapting, and obviously you have, if you've been watching the trial on Minnesota, you see the social distancing, how they have the screens, how everybody's separated, and Judge Marisco brought up a good point in the beginning where a lot of people were apprehensive about wearing masks and being able to see people's facial expressions, and a lot of people were making constitutional arguments, and that just goes to show that, when your Con Law 1, your Con Law 2 professor tells you that the Constitution is a living and breathing document. I mean, it really is. I mean, look how it was put to test with all this craziness here, like, where your Rule 600, your confrontational clauses. People also thought that because this happened, that there wouldn't be as many crimes committed. Well, no, people get to sit around more and they get to think and stew. And like Attorney Sunday had said, that, people are home, and normally you're not home with everybody all the time. And that could exacerbate a situation, especially in the domestic violence front. And it also something that Attorney Sunday said that really hit home. It's really frightening to think that, you have a lot of the child abuse cases are made either by the child coming forward or by a mandated reporter coming forward. And it's, from a human aspect, just because you're a criminal defense attorney doesn't mean that you respect and follow the law and firmly believe that everybody else will respect and follow the law. It's frightening to hear that these kids have to be stuck in their house with their alleged abusers. I mean, it's just a really tough time. It's a really tough time, more so for the prosecutors and for the judges, but they've done from everywhere in Pennsylvania, they've done a phenomenal job. And it's an honor to be a part of it, because this could have went the other way quick. This could have went south, especially when Attorney Sunday talked about the prisons. I can't tell you how many people that had called me, my clients that were incarcerated in jail waiting for a hearing. They want to get out of jail. All of a sudden, some had some pretty serious health ailments. Some, maybe they may have been fabricated, maybe not, but you have to do your job. And in the beginning, I know the courts were flooded with COVID-19 requests for bail reduction, put on scram house arrest, furloughs, and a lot of them had to be met. And it was a double-edged sword, because you keep these people in jail that are high risk, and God forbid if something happens and they get sick, not only will they get, but there's a possibility their health be detrimentally affected or die. You push it through the whole jail. We had a situation up here where a woman was incarcerated on, I don't want to say a minor offense. It was an offense involving a nursing home. They let her out of jail. Well, she ended up murdering her fiance, and they let her out of jail early. So there was a lot of bad press there. And no one, judges don't know. You don't have crystal balls that if somebody's going to do something when they get out of jail on house arrest. And it was just a real tough situation. Should that person have been allowed out of jail? And there was no indicators that there was going to be any issues like that whatsoever. But for COVID, the house arrest petition would have probably been denied. But again, everybody's moving forward and trying to make the best decisions, but there's no measuring stick on what's going to happen if I decide this, what's the consequences. I mean, but so far we've been through this pandemic for 14, 15 months. And, absent a couple bumps in the road, it has been going pretty smooth. And that's nothing but a testament to our court administrators, to our benches, and our district attorney's office across the state. And that's all I have. But I just want to say, I want to thank Mr. Sweetman. I want to thank the faculty of Widener, and I also want to, thank. It's an honor to being on such an esteemed panel with Judge Marisco and District Attorney Sunday.
Thank you so much, Attorney Mattioli. And now I'm going to turn it over to Professor Bookhandler Raphael.
Thank you. So first of all, thank you to all three panelists for these wonderful presentations. Your practical insights were really fascinating for me to hear. So I think one thing for sure is that the COVID-19 pandemic has definitely shown a light on pre-existing problems in the criminal legal system, which is of course fraught with many, many problems. So one particular issue that I'm wondering about and have concerns about is, and some of the panelists have touched on this, is what practices in criminal proceedings will remain with us post-pandemic, because now it's clear that we're getting out of the pandemic, but still, the CDC still requires everyone, even those who've been vaccinated, to still wear masks. So definitely during the court hearing. So we've heard about constitutional concerns, especially the confrontation clause and how that right is the right to confront witnesses, how that is affected. But I was also wondering about some evidentiary issues apart from constitutional concerns, because demeanor is considered a critical tool for assessing credibility of witnesses in court. And evidence law tells us that we fact finders must assess the whole facial expression questions to be able to evaluate, to assess demeanor. But then there's a serious question when we have in-person hearings, when parties or victims, defendants, when they're all masked, you know, the nose, mouth, chin are all covered, how are fact finders to assess, evaluate the credibility of witnesses? Which brings me to the question of whether the whole pandemic is, you know, an opportunity to reassess, reevaluate the role of demeanor, in credibility assessment. So is that going to change? And relatedly, so this is also a question that we've heard from one participant in the audience. Again, it's clear that some virtual practices will likely remain with us, even post-pandemic, due to, you know, efficiency concerns, money. It's cheaper to have virtual hearings. So do you believe that many video conferences will, you know, remain post-pandemic? And what concerns do you predict in this post-pandemic world? So question to all three panelists. Thank you.
As a judge of credibility, I guess I'll start and let my esteemed colleagues follow up. Yeah, it's definitely harder to judge credibility looking at a little square, you know, on the phone, or, you know, somebody that's masked up in the courtroom. But I think for now there's sort of a trade-off, you know, of, you know, keeping this system moving. For example, in juvenile court, we've made a decision. You know, we've done some adjudication hearings virtually, but we're not going to do a sex case virtually in juvenile court. A drug case where maybe the cop's the witness and he says he found, you know, heroin on the juvenile, where, you know, demeanor isn't going to be that much of an issue. Not that it couldn't be, but, you know, those types of cases are easier to proceed with virtually as sort of the professional witness type case, you know, to go on. So yeah, I think it is a concern. And I've had occasions in the courtroom where, just with the difficulty with hearing individuals, I've had to say, you know, if you're comfortable, you can pull down your mask. The witness stands, you know, far enough away from everybody. You know, I had a child witness in a trial before me, and the kid was just hard to hear. And I said, "Are you comfortable taking off your mask?" And he said, "Yeah." He took off his mask, and then it was, you know, much better in that sense. So, you know, there's still some wiggle room. Even with all the administrative orders, ultimately a judge in the courtroom, you know, is going to have some discretion, you know, in those types of cases.
And just to piggyback off of what Judge Marcico said, one of our jury trials in York County that are going, our courtroom essentially, there's plexiglass sort of everywhere, and it looks like a plexiglass maze. If you run too hard, you're going to hit something, right? Like, and so, but what that has done is it puts us in a position where we can be much more liberal with mask removal, and so that has sort of done a lot to address that concern. With regard to preliminary hearings, and I know this is, you know, it's controversial, it's something that we could argue about till the end of time, but the reality is that credibility is not at issue at a preliminary hearing. And so that is what gives a lot more leeway with regard to, at least in my opinion, with regard to the preliminary hearing testimony. I'm sure that defense attorneys, and I'm sure that, you know, my esteemed panel colleague would definitely probably touch on this, is that even though that's the law, preliminary hearings are used for a lot of things strategically by defense attorneys. And if I were one, I would do the same thing. And so this has just, you know, really caused some issues. And so my hope is that, and all of our hope is that, as time goes on and we get to a place where the science is such that people feel comfortable being together again with masks off, then we'll be in just a much better place. There is no answer for this. We just have to do the best we can to make sure that people's rights are protected, and at the same time, the community is safe.
I think just to touch off with both gentlemen said, I agree 100% with District Attorney Sunday that there are some advantages and disadvantages to the prelim. The prosecutor always likes to say credibility is not an issue. We love to say it is. So you'll find the rule somewhere in between, whichever magistrate that's presiding over the hearing, however they want to proceed. But I think that once everyone becomes more comfortable, once more people get vaccinated, I think we're going to be able to get back to the live in-person prelims. But what I do think, just to touch base on what was said, what I think is going to stay is maybe the pre-trials done by Zoom, because it seems to be so much more efficient. It's normally just a cattle call. What a pre-trial is, like I had said a little earlier, there's like 150 cases on the list. Judge calls your case, you go up, you say trial, I need a scheduling order, or it's going to be a plea, you hand in your colloquy. That's been done seamlessly here. And I know the judges enjoy not having to have everybody in the courtroom because it's an all-day event. I do a decent amount of personal injury. Just to switch gears a little bit on the civil side, I think we all learn now that there's no need to travel out of state. There's no need to travel across the state. If we need to do a deposition, we can do it by Zoom, and it's just saves so much money and so much time to do so. So I think that out of this pandemic, we're going to keep some things, maybe the pre-trials, definitely not the in-person hearings. Whenever the medicine catches up, when everyone gets vaccinated and the infection rate isn't so bad. But I think that they're going to keep the pre-trial. I hope they keep the pre-trials, and I hope that we can still practice civilly as well with Zoom.
I think also, very quickly, I think we also should not underestimate the joy that judges have, because I've heard this from other judges about the mute button.
So thank you to all of our panelists. I think we have a little bit of time. We have 3 minutes left. So I'd love to take some questions from the audience. If you want to raise your virtual hand and then you'll be muted. I see, who do I see? I see Jay Holstein. Could you unmute yourself, or you unmuted? Jay Holstein's hand is up in the raised. No. Does anyone else? I don't see another hand. I see Yanis Kormas' hand raised. Could you please unmute yourself?
Hi there, thank you. Can you hear me?
We can hear you.
Yeah, great. First of all, thank you very much for everyone here, like sharing your knowledge and your best practices. It's really appreciated. I would like to ask something that actually, given many of our own experiences, of the difficulties of virtual conferencing, COVID had a lot of impact in many aspects. But what I want to notice is that it's quite increasingly clear that Zoom fatigue is a demonstrable detriment of working online. I've read about the famous Israeli parole board study where they suggested that tired and hungry judges make harsher and more risk-adverse decisions. So taken together, this suggests that the extra mental burden involved in virtual hearing may increase the fatigue of judges, which may in turn impact upon the quality of the decision making. And I would like to ask, what are the steps that you're taking in order to prevent that, in order to, let's say, not having systemic bias in decision making? Thank you.
Hey, yeah, I think it's a good question. There certainly is Zoom fatigue. And sometimes there's some frustration, when the technology is going bad. Attorney Mattioli talked about, whether by intent or otherwise, someone goes off on a call, the Wi-Fi goes down. It does get frustrating when that keeps happening over and over. But I think, the same things happen, I think, in person in court, where you can get very frustrated with different things. So, yeah, I mean, I think there is some danger with Zoom fatigue. But yeah, as you can still take breaks. You have to remember, I got to give the court reporter a break. We talked about the issues of having interpreters on Zoom calls and the nightmare that becomes. So I think you just have to, know what everybody's going through, in those situations and handle it accordingly.
Okay, I think we're out of time. So thank you so much to all our panelists and to everyone who participated. And it was really wonderful to hear from all of you. We all learned a lot. Thank you.
Thank you for having me. Nice to talk to everybody. Everybody have a great and safe weekend.
Yep.
Thank you all.
Thank you very much.